All rise.
Good morning. Please be seated. In our third case today, Reed Havel versus the Board of Zoning Appeals, City of Kent. On behalf of the appellant, Mr. Thompson. Good morning.
Thank you. Good morning, Your Honors. Maurice Thompson, 1851 Center, joined by counsel for Pacific Legal Foundation and Ohio Realtors today. I'd like to reserve 4 minutes for rebuttal, please. May it please the court, for well over a century, this court has correctly recognized homeowners' property rights to be fundamental rights, and that restrictions on these rights should not be beyond what is necessary or unduly burdensome. Despite this, the City of Kent attempts to operate as an involuntary HOA, limiting 6-bedroom homes to just 2 unrelated adults, without a single health, safety, or nuisance-based justification. Applying this occupancy restriction to Mr. Havel fails scrutiny for at least 4 reasons. 1, simply labeling rights restrictions as zoning does not in and of itself immunize them from constitutional scrutiny, and the justification for heightened deference.
Should we even get to the constitutional issue in this case? I mean, there seems a pretty compelling argument that this doesn't even violate the zoning code.
Yes, Your Honor, you should reach the constitutional issues for several reasons.
Well, but if you can win on a non-constitutional issue, why wouldn't you want to do that?
Well, we don't know that we
can. In your client's interest?
We don't know that we can win on a non-constitutional issue. The city has, since 2022, maintained a very clear policy that it's applied to Mr. Havel.
But your client won in the trial court.
Yes.
In the Court of Appeals, won in the trial court on just the application of the zoning code, which I have to say on its face, trial court clearly seems to be right. The Court of Appeals then reverses that. It does it based on an argument that wasn't even really raised in the Court of Appeals. But then you've appealed to this court and not even raised that issue, which, you know, one of our principles is a constitutional avoidance principle, that if we can resolve something on non-constitutional grounds, we should do that first. And here, you have an as-applied challenge, so I don't even know how we can get to an as-applied challenge without construing the zoning code and whether the zoning code actually bans that.
Well,
so I mean, I don't understand why you're arguing against that.
There are a few points, Your Honor, some practical and some doctrinal. As a doctrinal matter, if you're going to apply the avoidance canon, then you would have to attempt to construe. You look at the city's construction of their zoning code and say, hey, we've got to construe this as constitutional.
Well, we don't even have to. I mean, there's 2 avoidance canons. One is, the first one is that you simply deal with statutory issues first. The second avoidance canon is that if there's some ambiguity, that you construe that in favor of it being constitutional. But here, if there's no ambiguity, we don't even get to that second level of avoidance canon.
Yes, well, I agree with that. You have a well, first of all, the trial court did reach the constitutional issue and found that the city's occupancy restriction was impermissibly arbitrary. Quite correct in our view, and we explain, in detail why that is. The Court of Appeals then did reach the constitutional issue as well in a way that cannot be left unsettled, and it would be potentially left unsettled if this court sidestepped it completely, and then that would be the Court of Appeals sort of making the constitutional law for the state instead of this court doing so, which we found objectionable, unless there's some way around that. And the reality is that...
Well, if we reverse the decision on whatever grounds, that decision is no longer law.
Well, the reality is that the city of Kent, for almost 4 years running, has told Mr. Havel that, as a matter of policy and practice, irrespective of text, has told Mr. Havel, you are running a rooming house when you allow more than 3 unrelated individuals to live there. That is our policy. That is our practice, whether it's written that way or not written that way. And you have to evict, however many of your tenants is over the number 2. And the city is obviously extremely wedded to that policy. They've taken it all the way up here. So if there's some semantic issue with how it's currently written, they're simply going to rewrite it in response to this court opining on that semantic issue, and we'll be right back here probably another 4 years from now. So the city is clearly chained to this policy, and it has been very consistent for 4 years that under its definition of a rooming house, which I see as fairly clear, anytime rooming house is not a permitted use in this zoning district,
right, but,
and a rooming house is more than
but
3 people living together.
a single family dwelling is, and a single family dwelling is defined. If you work through the definitions, to include a household of 3 or more unrelated individuals.
That's right. That's right. It's a messy set of definitions, to be sure, but the city has interpreted its code and applied it to Mr. Havel as though his single-family home, built in 1931, often occupied by many people, is a rooming house when occupied by more than 2 people, and it has threatened fines and evictions, daily fines up to $300 per day for each day that he leases to more than 2 unrelated individuals. So that is the situation that we confront, and we take it as the city gives it to us and as the Court of Appeals gives it to us, that this is the city's policy and their practice that we're confronted with. And we're confronted with it in the face of cases like Yoder, which say these kinds of restrictions are impermissibly arbitrary, they are beyond what is necessary, and they are beyond the reach of the Ohio Constitution, given that Ohio homeowners do enjoy more property rights, both in the text and the structure of the Ohio Constitution, than the federal baseline. So as opposed to that federal baseline articulated in Belterre, what you have here is a basis by which this is immediately suspect, and you have decision directly on point, like Yoder v. City of Bowling Green, that demonstrates how this policy is unconstitutional. And it is important, in our view, to reach that decision. And it's important to reach it because there's an infinite number of less intrusive alternatives to achieve whatever the goal is the city is claiming that it's attempting to achieve here. And we've cataloged those, and it's also important because of the text and structure of the Ohio Constitution and the fact that the municipal police power does have to have some sort of an outer boundary that a policy like this exceeds when it regulates the internal composition of the home based upon the tenant's characteristics rather than based upon the physical structures and other things outside of the home.
So if we were to reach the conclusion that it is appropriate to observe the doctrine of constitutional avoidance, would you be wanting to have the opportunity to brief on the issues of why the property complies with the municipal ordinance?
Why the property complies with the municipal ordinance? You mean why the property cannot be penalized? Why Mr. Havel cannot be penalized as a matter of the ordinance?
Correct.
Yes, Your Honor, we would have to supplementally brief that issue. It's not within any of the 3 propositions of law posited here. It is beyond those, so we did not brief it in our merit brief or in our reply brief, unless you interpret it as glancingly reached. But other than that, we've submitted the 3 propositions of law, all on constitutional grounds that we've submitted. The trial court did reach the constitutional issue. The Court of Appeals did reach the constitutional issue. So we do think that it's extremely important that that be corrected in a way that settles this matter once and for all in the state. But if the court wants to look at the avoidance issue, I still think if you're construing the city's ordinances, you need to look at construing them as consistent with the Constitution or not. So you're still going to reach some level of constitutional analytics, irrespective of how deep that goes. But the answer is yes, you would order us to supplementally brief the issue in that.
And you'd want that opportunity, correct?
If the court orders that, we will do that.
Thank you.
However, I do want to point out that there is absolutely no justification for the typical kind of deference here, the heightened zoning deference that this court has typically afforded because of this unique feature where, when we're looking at zoning, we're typically looking at structures, lots, protecting homes from nuisances, heavy industry or commercial uses in residential zoning districts, height, depth, open spaces, setbacks. And what the city is doing here is instead regulating on the basis of relationship status. And the idea of deference to the city's zoning code is based largely, it's a judge-made doctrine. The word zoning is nowhere in the Ohio Constitution. And this court can roll back that deference whenever it is unjustified. And we think because this is not a traditional zoning regulation, the court should apply a more rigorous degree of scrutiny. And even under basic scrutiny, when you look at the ordinance, the way that it is written and the way it has been applied to Mr. Havel, there are so many less intrusive alternatives for reaching whatever goal the city wants to reach. The city could.
So I'm on your constitutional arguments, trying to understand the source of your arguments.
Yes.
You certainly have the argument about the provision in the Ohio Constitution that says private property shall be inviolate, or that provision. But what I don't see in your briefs is any argument about the home rule power. I mean, the city has home rule authority, but that authority is to enact police and other similar, I don't have the language, but it's a police power. And I mean, why aren't you arguing that this exceeds their authority under home rule, under the delegation of police powers to them?
Your Honor, Proposition 2 of our brief, which is the largest section of our brief, is dedicated to precisely that.
But you don't only talk about the home rule.
Well, we talk about the police regulations. So there are home rule provisions, and then there are police regulations. The city has maintained consistently.
The city only has the authority that's delegated from the state, right? So it's a.
Well, if we're talking about Article 18, Section 3, it contains at least two different sources of authority: home rule powers and police regulations, which are separate from home rule powers. The city is maintaining this as a police regulation or a municipal police power. And what we're arguing is that the municipal police power has always, before 1912, at 1912, after, in the original public meaning as would have been understood by Ohio voters, had an outer boundary, or else they could have just written the city can make any regulation. The word any is over 100 times in the Ohio Constitution.
So where does that outer boundary come from in the Ohio Constitution?
The original tethering is to common law nuisance principles. So the idea of Tiedemann and Cooley that influenced the meaning of police power in 1912.
But there's obviously different conceptions of state power, right?
Yes.
There's some would advocate that states have plenary power if it's not excluded in their state constitution. They have that power. Others have a more limited view that it's based on some formulation of police powers. But what I'm asking you is, where in the Constitution does that come from? Is there any provision that you point to? I mean, to course of law, to the Article 1, Section 1. Where do you get that limitation?
Yes, just like in the federal Constitution, say you have a Commerce Clause claim like we heard earlier today here, and then say you also have a First Amendment claim of some kind. The first question you ask is, does the city have the power? And if the answer is no, you simply stop there. If you believe the city does have the power, then you move over to the right section. Is there nevertheless a right that stops that power, even so? So in the first instance, does the city have the power? Is this a permissible police regulation when it is not at all an attempt to apprehend a nuisance, or at least there's no theory, the only theory put forward by the city is administrative convenience to the city itself, from how we interpret what they've said. So the Constitution doesn't say the city can implement any regulation it wants. It says police regulations. There's a term of art in 1912 that was understood as the city can regulate to stop a property owner, for example, from using their property in a way that poses a risk to others or actually injures others' equal rights. That's the Lockean conception of the Ohio Constitution that this court has found exists. So you stop there if the city doesn't have the power. Now, if you find that they do have the power, you move over to where are the rights. And the power for an occupancy restriction would be by implication here. So rights can be by implication. 2, Section 1, Article 1 is where we think that a right like this, a property right, belongs to be housed specifically because it articulates property rights, identifies property rights, and the right to use, possess, enjoy property, as opposed to the condemnation clause in Section 19. So you would begin there and look at the fact that there are rights that can exist by implication. Otherwise, we wouldn't have parental rights protected by the Ohio Constitution, which we all agree we do. Privacy rights that this court identified in Saunders, not explicitly articulated, but we all agree it's there. The question is, where is it? And I think that the answer is to rediscover Section 1, Article 1, and the older case law that shows that that is an independent source of right, all the way through direct plumbing supply and Pisa versus Rescala in 1998. And I see I'm into my rebuttal time, so I will sit down and be back.
Thank you. On behalf of the Appellee, Mr. Fusco. Good morning.
Good morning. May it please the court, Chief Justice Kennedy. My name is Mark Fusco, and I represent the Appellee, the Board of Zoning Appeals, City of Kent, in this matter. I agree that this case should not be decided on a constitutional basis, that this court should avoid ruling on the constitutionality of the ordinance in question, because it can reach a decision based upon the application of the ordinance itself, which the Court of Appeals
The only way
consider.
to avoid it would be to reach a decision unfavorable to you.
I understand that, Your Honor, but I disagree with, I think the Court of Appeals did address that issue. The Court of Appeals addressed the zoning ordinances and came to the conclusion that this was not an appropriate use of the property within that district.
Right, but if we would decide this on constitutional avoidance, then we would reverse the course of the Court of Appeals. If we don't reverse the Court of Appeals on that issue, we'd have to get to the constitutional issue.
I don't think the Court of Appeals decision on that basis should be reversed. The Court of Appeals took into consideration the definitions, the definitional section of the ordinances, along with the restriction on how many people can occupy that residence, and came to the conclusion that
Well, the only restriction is in the text of your code is it says that 3 or more unrelated individuals can be in that residence.
more than 2, yes. It's restricted. You cannot rent that property to more than 2 individuals.
Well, let's talk about that, okay?
Yes, Your Honor.
The other side uses the example of 3 nuns. Why can't 3 nuns occupy that house?
They're not related. Your Honor.
Right, so what's that going to help, Kent?
Well, so if you have to go back and look at, so I know there's been reference to Yoder, and the Yoder decision was that the purpose of the ordinance in Yoder was to regulate density, but it really didn't regulate density, because whether it was 1 individual, 2 individuals related or 2 unrelated individuals, the density was the same.
Correct.
Here in this R3 district, what the City of Kent is trying to do is to promote single-family development within the R3 district. And it's only within the R3 district. This is not a prohibition across the entire city that you can't have 2 or more unrelated.
Okay, you're talking to
individuals.
somebody who had 9 people living in the 3-bedroom house growing up.
Pardon me?
Okay. 9 people growing up. When I was growing up, I had 9 people in a 3-bedroom house, so you're going to have a lot to show me here.
Okay. Well, Your Honor, there's a difference between, I assume this is a family unit, 9 individuals. And
Sure.
Sure. Well, probably not all 9 individuals at the same time had an automobile. If you have 9 renters, they likely all have automobiles. They likely have to park those automobiles somewhere, and that taxes the resources of the city, especially this time of year, on off-road, on parking.
So
People are
three
parking in the
nuns would
street.
tax the police power of Kent?
Pardon me?
3 nuns would tax the police power on parking?
If 3 nuns with the cars, more than 2. The city chose 2 and not 3.
But you could have 9 related individuals living in that house. And they could have more than 2 cars.
They could. That's
So,
certainly.
so how does that help?
But there's something in the record to suggest that the 9 individuals who are related living in that house each have access to their own vehicle. I think you could,
So what if you have one person living in a house and they own 5 cars? You're going to start saying you can only have 1 car?
well, this is based on,
Well, I'm just using your example of cars as
Yes, sir.
being something that Kent has some reasonable basis to then make this restriction. You're the one who used the word cars, so if you're an individual living in a house alone, but you own 5 cars, you're going to start saying, if one person, 1 car?
well, there's no evidence that these cars would impact the provision of public services. There could be a separate ordinance saying that if you have 5 cars, they have to be garaged in a certain fashion. Here, it's more than 2 individuals. So to use your example, if there's 9 unrelated individuals living in tenants in this property, that's going to be they're going to use more public services likely than 9 family members.
So it is geared towards density then?
I'm sorry?
Well, you said over and over in your brief that this isn't about density, but what you're saying to us is it's about density because if you have more people, they're going to use more services.
It's encouraging this type of restriction and encouraging
But-
single-family development only in this R3 district.
Okay, but if you have 9 individuals, all related, using water service or sewer service, whatever, they're going to use more than 5 individuals who are unrelated using the same services, correct?
That's certainly a possibility, Your Honor.
So why does the unrelated, I mean, I read your thing and I have a daughter and a son-in-law and 2 grandchildren. I can live with them, but my brother, who'd be the great uncle, can't? That's the way I'm reading your,
Yes, Your Honor, that is the way the ordinances are created. That's the way that the city decided to draw the line at
isn't
more
this,
than 2 unrelated individuals.
isn't the city really drawing the line to prevent housing for Kent State students?
There's no evidence of that in the record, Your Honor.
Okay, but isn't that what we're really talking about?
Well, Kent is a college town, but again, this is only in the R3 district. This does not apply to any other districts within the city of Kent. It's only in the R3 district, which was created to promote single-family dwellings.
Well, let's say you have a couple, not married, who are raising foster children occasionally to help out. They're 3 unrelated people. They would be prohibited from living in that house, correct?
You could apply for a conditional use permit to run a group home, but you would have to first.
But that was
satisfy-
denied in this case.
Pardon me?
He applied and it was denied in this case?
You first have to apply for a license from the state of Ohio to run a group home. Once you have that license, yes, then you could go back and make an application for a conditional use within that district. That's not what happened here. If someone wants to create a group home in this district, they would have to get a license from the state, go back to the city, and ask for a conditional use permit for that purpose.
Instead of nuns, let's use Jesuits. I went to a Jesuit high school. They live in community. Let's say 4 of them want to live in this house with 6 bedrooms so they have enough room to write and to read and to study? That would be prohibited, correct?
That would be prohibited, yes.
And what's the constitutionality of that?
Well, the constitutionality, if we're going back to the constitutional question, the United States Supreme Court in the Belterre case decided in 1974 said restrictions on unrelated individuals in a single-family property was constitutional.
In the Norwood case, this court has said Ohio doesn't have to follow the federal rules on that, correct?
That's correct, Your Honor, but I would encourage this court to follow that rule, which has been in place for almost or more than 50 years.
So your ordinance doesn't specify that if somebody does get a group home license from the state, that they would be approved for a conditional permit or a variance, correct?
A group home is a conditional use within that R3 district.
Is it automatically granted?
It would have to go through the process, the zoning process, but it should be, yes.
Under the statute, it could be turned down, though, correct?
You mean under the,
Under the ordinance, it could be turned down, correct?
it could be turned down, but that's not the facts of this case. So an individual who owns a home in that district and wants to operate a group home can get the proper certification from the state of Ohio and apply for the conditional use permit. It should not be turned down.
Under Yoder, private property rights are fundamental rights under Ohio's Constitution, correct?
That is correct, Your Honor.
So that makes your zoning ordinance subject, at least on this point, subject to heightened scrutiny, correct?
The only case that applied heightened scrutiny from this court was the recent, well, not so recent decision anymore, having to do with eminent domain, where this court applied a higher standard of review. Yoder was a federal court applying state law. It was not an Ohio court applying Ohio law.
That's correct.
So I'm still trying to figure out the justification, your purported justification. I mean, what you write over and over your brief is it encourages single-family development at higher densities and provides a more orderly and efficient extension of public service facilities. To me, that's kind of gobbledygook. What's that mean? I mean, the only thing I've heard you say is, I've heard you say that, well, there could be parking problems if there's more people living in the house, and that this is kind of a de facto density regulation. But what you say in your briefs is this is not about density. So help me understand what the purported justification is.
Well, the R3 district, again, is to encourage higher density with single-family higher density within the R3 district. So it's
Single-family higher density within the
R3.
So it's to encourage, but I thought you just said that it would, that one of the objectives was you didn't want so much density, so many people living there, because that would create strains on public services.
Again, Your Honor, this is based on the family unit. So the city of Kent has decided in their definitional statutes what constitutes a family unit. A family unit they're encouraging family units to move into this higher density area in the R3 district. That's a policy decision made by the city.
So it's just about families.
It's about single family.
So I mean, it's about the relationship of the people who live here. You want certain kinds of.
That's correct, Your Honor, because the family unit is defined as two married individuals or two individuals who are in a recognized civil union. So, and or within certain degrees of, and I'm going to get this word wrong,
And so what does the family unit part of it have to do with the delivery of public services?
It's targeted.
How do three unrelated individuals, three nuns or whatever, get different public services than two married people and a kid?
Okay. Again, to go back to the parking example or the vehicle use example, and this is not something that's in the record, But if there are 8 tenants, adult tenants, and they each have a car, that's not likely to occur with a single family.
Wouldn't it
with
just
8.
be easier to just have some parking regulations?
Well, there are parking regulations, Your Honor. I'm sure there are parking regulations within the city.
So what happens if one of the two in the couple dies? Do they have to move out? I mean, if you've got two individuals in a union or a married couple and one of them dies, does the family have to move out?
No, Your Honor. A single person could also reside. The definition of family in the ordinance also includes a single person living in that home.
So a
So
single
to-
parent could actually live there?
A single parent could actually live there, yes, Your Honor.
So you,
And
let's
a
say,
single person could, it doesn't have to be a parent, but a single person could actually live.
let's say you have 2 parents and they're in the process of adopting 3 kids who are unrelated. Do they have to not live there?
An adopted child,
Not adopted, in the process of adoption.
until the adoption is completed, yes, Your Honor,
They cannot live there?
they could not live there.
So it's against families living in that district.
Well, I don't, it's not, once the children are adopted, they're part of the family. but
Right,
until
but
they're adopted,
this is in the process. It takes a while for adoptions, as you know.
yes.
So they can't live there. So this ordinance is actually partially anti-family.
I don't agree with that, Your Honor, because I don't think, until the adoption is complete, it's not a family unit. It may be a family
And so they
unit.
can't live there.
They can't live there, because they're not part of the family.
You think that's constitutional under the state constitution of the state of Ohio?
I think it's a valid exercise of the city of Kent's police powers, yes, Your Honor. But again, that's not the issue before the court. The issue before the court is whether Mr. Havel can rent this particular single-family home in the R3 district to more than 2 unrelated individuals. And with that, I see my time has expired.
Thank you.
Thank you.
Mr. Thompson, you've used your time. I'll give you a minute.
Thank you, Your Honor. We've heard a more concise justification for the zoning restriction here as based upon parking and automobiles, but you can regulate parking directly. I'd also point out that our client, Mr. Havel, who has a 6-bedroom home, has 6 off-street parking spots, and this is an as-applied challenge, so he doesn't pose a threat to the parking in this particular situation. But you can also regulate the number of cars directly that people have, rather than regulating the number of people that live in the home. There are other ways of doing this. Every other city in Ohio has found another way to do this, to advance single-family residential without this kind of occupancy restriction at this point. The sky didn't fall in Bowling Green. They limit the number of tenants by bedroom there. You can also do it by square footage. You can also do it by available off-street parking spaces, all of which are far less intrusive and less invasive than what you have here. It's also arbitrary because, as you heard, 10 third cousins could live together, 10 teenage third cousins with cars could live together in Mr. Havel's home under the city's ordinance, but 3 nuns, to Justice Fisher's point, cannot. So there is no connection. And in fact, with respect to family values, you could have 2 unrelated individuals with no children, no other family in every single home in this zoning district at the same time. So you just have no relationship whatsoever to the city's police powers, and you have an intrusive violation of Ohioans' property rights. And for that reason, this court should reinstate the trial court's decision finding that the Kent ordinance is unconstitutionally arbitrary because it is unduly burdensome and beyond the necessities of the situation.
Thank you.
Thank you.
You'll receive a copy of the decision from the court.